Welcome back to the Build Right podcast. We build knowledge, insight, and connections into the world of construction. Whether you're a seasoned contractor, builder, or just curious about the industry, we break down the latest trends, tips, and technologies shaping the future. Join us each week as we chat with experts, share stories from the field, and explore the challenges and triumphs that come with bringing our visions to life. Welcome back, everybody. I'm your host, Scott Raffensperger. With me today is Jack Phelan of Phelan, and Danik. Say hi, Jack.
Hello, everybody.
Thanks for coming on.
My pleasure.
So explain to everybody what you do.
I'm a construction litigation lawyer, and I've been a construction lawyer since the early 90s. I represent general contractors, developers, subcontractors, owners, both commercial and in residential.
Nice.
I try to stay out of residential if I can.
Why is that?
Because the scope of the dispute usually don't warrant the legal fees, to be fair. And you're not going to think I'm much of a lawyer if you got a $40,000 dispute and it costs you $80,000 to recover it.
That's fair.
Yeah. So I try to stay away from them when I can.
Yeah.
When it comes to residential construction disputes, I'm a big fan of arbitrations, mediations. I actually serve as a construction arbitrator and mediator for the American Arbitration Association in their construction division. Mm-hmm. So it's usually a cheaper, quicker alternative. And if you limit the size of your dispute, you can even just do it on a submission or on paper basis. And I think if it's less than $75,000, the cost is probably a couple of grand.
What does that arbitration consist of?
It can run the gambit. It can be you put in your paperwork, the other side puts in its paperwork, and I make a decision without ever seeing any witnesses. It can be, let's just go have a one-day hearing, and you guys will put on your case and you put whatever witnesses you want. The more complicated cases can be a week, 2 weeks, and they'll have some discovery going into it. Those can become expensive. And I try to limit the discovery that I'm going to allow. And by way of discovery, I mean like doing oral depositions, things of this nature. Usually if you give me the paperwork, I can figure it out pretty quickly.
Yeah.
But some people, some lawyers like to hear themselves talk.
The longer it goes, the better it is for them, right?
Well, they're getting paid an hourly wage.
Yeah.
And sometimes that is a disincentive to just getting to the point.
Yeah. Is that more casual setting?
Yeah. Again, it depends a little bit on the players, but I like it to be casual. I don't think it should be a stressful environment for lay people coming in who have a valid construction dispute. But it kind of depends a little bit on the players, but I like to keep it casual.
Is that in your office, or do you do that in a courtroom? Is it like across a table? You're having
No, usually I'll do it in my office. I don't bother with a courtroom. It's more of a, if there's a conference room, we can do it in a conference room. Mm-hmm. The last one I had, literally the stucco on a building over in Broadway in Schenectady fell into the street. Wasn't that hard to decide who was involved.
Yeah.
I was a little surprised that they asked me.
Yeah.
But be that as it may. Yeah, so they run the gamut. And what's nice about it is you can manipulate the proceeding to fit the scope of the problem, as opposed to, lots of times in a relatively small dispute, an actual lawsuit and litigation and a trial is like, shooting a fly with a shotgun, because that's easily going to cost you over $100,000.
Is there a flat fee for the arbitration stuff, or how does that work?
It's usually by the hour, and unless it's the limited one. The AAA does have a flat fee for, I'm trying to think, the dispute is limited to $75,000, and I think the flat fee is a couple grand. Okay. And then they have a smaller fee if you're just going to hand me, some paperwork and ask my opinion.
Okay.
And the least informal way is mediation. The problem with mediation is I have to cajole you to actually participate, because I don't really have any power. As the arbitrator, I have the power to decide.
Okay.
and I much prefer being the arbitrator than I do the mediator.
So how do you go about adding that to your contracts? I mean, I'm assuming that's got to be a line item in your contract that it goes to arbitration first.
Yeah, it depends on who the client is. If it's a big, sophisticated client, a lot of times I will leave mediation and litigation as a dispute resolution clause in the contract. And the reason I do that is I don't want to make it easy for somebody who has a dispute with my big contractor to get a resolution. I want them to feel the pain. And so we will leave the litigation clause in there. What you'll see if you go and look at some of the standard documents on the commercial side, whether it be the AIA, which is the architect's standard clause, or the consensus docs, usually it's a selection process. You can select arbitration, you can select litigation. In New York and in most states that I'm around, litigation has to be commenced in the county where the project is located. So that can be kind of a pain in the neck if your contractor is from out of town.
Right.
For instance, we just had a client build a hotel over in Cooperstown, because it's a stick-built framing job. Actually, the framers came from Pennsylvania, and they're having a heck of a time resolving some issues because, despite all the signed change orders, they apparently can't add.
Yeah.
Ideally, if you start with a contract with a price, and you have deduct change orders and credit change orders, the number at the bottom should just be a calculator number. Unfortunately, for this particular contractor from Pennsylvania, that's too much for him. So he filed a lien for about twice as much money as he's got left in pay recs. Trying to explain to him that that's, first of all, it's illegal. It's an exaggerated lien, and you can suffer treble damages with that, plus attorney's fees. Trying to get him to acknowledge the problem and get paid, because we do owe him some money, has turned out to be a hell of a lift.
Yeah.
Sometimes I think a lot of these stick-built framers, it's mostly inexperience, either in how to get paid, or just as importantly, how to cost out the job. That's what a problem I've got with a client out in Cooperstown right now. And we're dealing with it. So that's generally how I approach dispute resolution. If it's going to be a small contractor or somebody who doesn't want to get stuck with a lot of legal fees, let's do arbitration.
Yeah.
And there's several ways you can do arbitration. You might have read about baseball arbitration. Baseball arbitration is you have your number and I have my number. The arbitrator decides either you're right or I'm right. There is no middle ground. So if you've brought an arbitration for $10,000 and I say I owe you $2,000, the arbitrator's decision is going to either be $2,000 or $10,000. And why that sometimes is useful is a lot of inexperienced arbitrators like to split the baby. Okay, they feel like that's like what Solomon.
That's quite the term.
Well, it's a Bible reference from Solomon. Unfortunately, they didn't attend the right Bible class, because Solomon only threatened to split the baby. He didn't actually split the baby. So you can get frustrated with certain arbitrators who will come down in the middle.
Yeah.
And lots of times it doesn't belong there. A lot of times, somebody's, particularly if they're inexperienced, is taking an unreasonable position. And what I've noticed with the sophisticated construction people that I represent is we try to resolve these things quickly.
Yeah.
Because there is a I like to call it a negative energy cost. I try lawsuits for a living, but lay people don't, and they find it a very stressful process. So there's a cost to that. And so a lot of times if I'm trying to get folks to resolve their differences, I will remind them there's a cost to the negative energy.
Yeah.
And so I try to get people to pay attention to that, because if they've never been involved in litigation before, it's a different process. I have a theory, I call it my 3 legal bill theory. You have a dispute with somebody. You want me to sue them. So you're all excited. Yes, go ahead, Jack. Sue that guy. When the first legal bill comes in, that's great. I told Jack to do that. Second legal bill comes in. Now, this is starting to hurt a little bit. This is getting expensive. But hey, I'm right. I'm right. So I'm going to get a resolution. By the time the third legal bill comes in, usually they're calling me on the phone saying, settle this case now.
Yeah. So you are a trial lawyer by trade.
Right.
But a number of years ago, when we had first met, that was one of the things I noticed was so different about you guys is your style is more straightforward. Let's talk this out. Let's resolve it. Sounds like this arbitration method is more along those lines.
Yeah, I mean, I grew up as a jury trial lawyer. I've tried over 180 jury cases to conclusion, which means I've started probably 400. There was a federal judge in Albany.
Do you know what your record is?
It's north of 92%.
But who's counting, right?
Who's counting? But there was a federal judge in Albany a few years back who tried to describe the difference between people who called themselves trial lawyers and people who call themselves litigators. And his description was a litigator has one file in his office, shows up to pick a jury with 22 boxes, and then settles the case. A trial lawyer takes a verdict on Friday and picks a jury on Monday. Mm-hmm. So you don't find many true jury trial lawyers in construction litigation. They tend to be construction lawyers first. I was a jury trial lawyer first. Mm-hmm. Until in the early 90s, I was fortunate enough to develop a relationship with a large contractor who did a wonderful job in educating me about construction. Yeah.
So how did you get your start? I know your start, but
I got
share for everybody else.
In construction, I got my start when a general contractor who I represented through their insurance company, and when they had a personal injury lawsuit, I would defend the company pursuant to their insurance. Called me up one day and said, "Hey, I'd like you to be our general counsel. We have a lawyer in house who's getting ready to retire." And we'd like you to handle all our legal work, not just the personal injury stuff.
How'd they get a hold of you? How'd they get your name?
They knew me through the personal injury work because I had represented the owners of the company when they would be produced for depositions and things like that. They didn't pick me as the lawyer. The insurance company has that right.
Oh, got it. Okay.
Yeah. But they knew who I was. And since I was fortunate enough to be apparently the only lawyer they knew, I was the one they called. And for the first couple of years, I sat quietly and tried to absorb as much information as I can or could. We had meetings every Friday evening, which usually involved a cigar and beer. And I would just listen to the week's events and try to absorb all that information that I had not been taught in law school. Mm-hmm. And that's how it worked out for me. We've tried a bunch of cases together over the years, but for the most part, we try to resolve cases. If I have a complaint about my fellow members of the bar, and I teach it to young lawyers in my office, law schools do not turn out people usually who are resolution oriented. They're process oriented, so they want to have a process. I'm more interested in is what does the client want? And that's usually how I start the interview. What is it you want from me? What is the result that you want? And I'll give you an example. It involves construction liens. Now, people who file construction liens usually aren't aware that lien is only good for a year. And you can renew it, but you can only renew it once. And then the lien expires. So the lien itself, unless the owner of the property is doing some refinancing, really has no teeth. Mm-hmm. And you can get yourself in kind of a mess. I had a client who got into a dispute with a landscape architect. That landscape architect filed a lien for about $85,000. We were having a beer one night, and he said to me, "If I had come to your office with this $85,000 lien, what would you have told me?" I said, "I would have said, is your financing in place?" He said, yes. I said, give me the lien. I'm going to put it in my drawer. And probably we're never going to talk about it again because they're not going to bring a lawsuit to collect an $85,000 lien. It's just hideously expensive. Instead, he hired probably the biggest and best law firm in the city of Albany, and they made several legal motions to try to get rid of the lien. They spent $146,000 doing that.
Oh, jeez.
And that's sort of the classic example of why would you do that? There's the lien by itself has no teeth. If you want to collect money on a lien that you have filed, you need to commence a lawsuit. Mm-hmm. So filing the lien really gets you nowhere unless you're messing up somebody's financing. Because then when they do the title work, this secure interest will show up in the line of title, and the bank that wants to lend you money doesn't want to be second in line. Mm-hmm. They want to be first. So you have two options at that point. You can either settle with the guy who's filed the lien, or you can file a bond. And what you do when you file a bond is you simply remove the lien from the real property and instead the lien attaches to the bond. It doesn't help you collect the money because you still have to bring a lawsuit against to foreclose on the bond. But those are the two traditional ways of dealing with liens. But for the most part, I ignore them.
Yeah.
There's no reason to spend any legal money to do that. I think maybe in 37 years of being a construction lawyer, I've filed a lien. If it's twice, it's a lot. Mm-hmm. Because what I'll tell the client is, if you want to collect the money, we're going to have a lawsuit. Fortunately, the client I've been with the longest has a great relationship with its customer base, and I think we have sued an owner twice, maybe. Mm-hmm. In both cases, the owner it's not that the owner didn't pay enough money for the work that was done; they didn't pay any money.
Yeah.
And if I build you a building and you paid me nothing, I may not be the greatest lawyer in the world, but I can win that case.
Yeah.
And so usually that's the way we've handled it. Sometimes I've had clients come to me and say they want a contingency-based fee arrangement. And by that they mean instead of being charged by the hour, they want me to be paid out of the proceeds I recover. You see that more in personal injury litigation where they get a third. But I've done that a couple of times where there were cases where the customer didn't pay, and it's been a very lucrative arrangement for me.
You have any good stories on that you'd be willing to share?
Well, there was one particular story where I can say the company, we built a bunch of Rite Aids, 7, 8, 9 Rite Aids.
Can we say what company was building them? Are we allowed to disclose that information?
At this point, we can. It would have been a company called BBL Construction Services. Mm-hmm. Back at that time, they would have been called Barry, Betty, and LeDuc, Inc. They're a very large general contractor. So they wanted to retain me, and Rite Aid had not paid for any of the Rite Aids, not a single one. And the owner of the company came into my office, and he said, I'd like to have you sue Rite Aid for me, and I'll pay you a 25% contingency fee because I don't want to be hourly billed. And I said, well, there's 7 buildings that are up and running. Yes. And they haven't paid you anything. No. Okay, I'll do that. How
does it even get to that point?
Well, Rite Aid was going through some financial difficulties at that time. And in corporate America, trying to find somebody to make an unpopular decision can be difficult. And people would rather put their head in the sand and hope that these lawsuits aren't coming. But eventually they're going to have to. It's a difficult process. We had a different dispute with a very large worldwide developer down in Florida, where rather than get caught up in who was at fault, we just decided to attack the problem jointly, and we just decided we would split it. Mm-hmm.
But I'm saying from a standpoint of, I know you're big on contracts. You've helped mm-hmm. us draft ours. And it's not like they put the foundation in and didn't get paid yet. There were 7 standing Rite Aids, if I heard that correctly, that they weren't paid for on Any of them?
Might have been 8. No.
How does that happen?
Sometimes if you're a contractor and you want to get your business going, sometimes you act as unintentionally as the bank, and that's what happened. Rite Aid, we're going to get paid. We're going to get you paid. We're going to get you paid. And by the time it got done, they were so far ahead. They just decided what they wanted to do essentially was negotiate. So let's say for the 7 or 8 Rite Aids, they were owed $4 million. So we'll give you 2.
Oh, jeez.
So that was sort of the game they were playing. And Rite Aid hired one of those litigation law firms I was telling you about. And the case was in front of a federal judge who they didn't know, but I had once worked for. And so they were admiring some pictures in his office that I had taken of downtown Albany buildings. And the judge said to these guys from Manhattan, "Oh, you like those pictures?" Jack took those pictures. Case, not surprisingly, the case settled very shortly thereafter. And I was able to achieve not only a great recovery for the client, but a nice recovery for myself.
That worked out good.
Yeah. The client wasn't all that happy with the size of the legal fee. I said, "Well, I just agreed to what you asked for."
Yeah, you brought it to the table. I just shook your hand.
That's all. In fact, there was a saying for a long time at BBL that the only one who made any money on the Rite Aid deals was Jack Phelan. And I suppose that's true. You can do things like that. I had one, and sometimes they'll convert. Sometimes they get tired of legal bills and they want to see if there's a way to convert a lawsuit into a contingency fee. I had one of those a few years back where the client thought he was going to collect about 150, and he offered me a third of the 150. I actually collected 650.
Oops.
I said, "You forgot. I'm a good lawyer."
Yeah. So you've done a lot of work with BBL, like you just said.
Yep.
You were friends with Donnie, right? LeDuc,
Yes,
before he passed.
Before he passed, and his kids and all of them. Yeah, I met Donnie when I was 12 years old. He built my father's fireplace. He was a colony mason, one of the brightest people I ever met. And he'd have 1,000 ideas in a day. 999 of them would be terrible, and one would be pure gold. Mm-hmm. He always had to listen because you never knew which one was going to be the pure gold idea. What really changed the course of the company and him was he decided to get into development. Mm-hmm. And development is where you can make some real money as a contractor. And what he would do is he would build an album worth of buildings and then sell them to a real estate investment trust, or more commonly called a REIT. And he would take that money and then build some more buildings. Mm-hmm. And it worked out very well for him. Unfortunately, he got sick and passed away in 2010. But the company continues to prosper to this day. It's a bigger company today than it was in 2010, I think. Yeah, sure it is.
What's crazy is that was 15 years ago.
Yep.
And still, I hear stuff every month. His name brought up probably once a month.
Oh, yeah. He was a larger-than-life guy, and he was great for this part of the state because he would go build things in neighborhoods that hadn't been touched in 3 or 4 generations. Mm-hmm. They redid the old Wellington Hotel. That hotel had been an eyesore for probably 35 years. It's a little unpopular, the vehicle that is often used by municipalities for that. It's a pilot program, and it's basically a tax break. But in order to make these projects work in this less than desirable location, these folks are for-profit people. They have mm-hmm. They have employees to pay, rent to pay. The cash flow has to work, and that's probably been one of the most eye-opening things for me as I proceeded in my career, is to watch these really bright people figure out cash flow, and how to make it work and how to get it built. They'll often take a haircut, because they think it's the right thing to do. We built a lot of buildings around Albany Medical Center in the Pine Hills. Would have been easier to make money building those buildings in the sand out in the suburbs, sure. But it was the right thing to do for the city of Albany, and so it was done that way.
So a payment in lieu of taxes, correct?
Yep.
Can you explain that a little bit more elegantly than I could?
Maybe. Basically what happens is you will make a pitch to whatever governing board you're talking about, whether it's a town board, whether it's the city, whether it's a county legislature, and you will try to come up with descriptions for your project. For instance, they want to know, how many new jobs are you going to create? What kind of revenue are you expecting? Around here, one of the masters of using the pilot program has been the Pyramid Company, who owns Crossgates. They just did a very unusual thing. Most people have heard that a Costco is being built on the loop road surrounding Crossgates. Pyramid had gotten pilot tax relief from the town of Gilderland, and they just turned it down. I don't know why, but it's because they've never been that bashful before. But that's how you do it. In other words, you're not paying property tax for a period of time.
Why would they turn it down?
I have no idea. But it was recently in the newspaper. And the people on the town board of Gilderland don't know either. I don't know whether it was a Costco-driven thing.
Like in good faith for the town, because I know there's always pushback in this area when you talk about pilots, because not airplane pilots, pilot agreements. But
for the most part, their pushback is either by people who have a competitive business already established. Like with the Costco, there were several lawsuits that went on for years, and they were mostly driven by the folks who own the gas station down the street. Not the people themselves running the gas station, but the people who own the land. Obviously, they didn't want competition. And other people who complain about pilots because, they are tax breaks going to usually wealthy people. But they kind of ignore the fact that you're getting something in return.
yeah,
You're getting a project completed, like the Wellington Hotel, that you wouldn't get otherwise. And up and down State Street, we did a very similar thing on buildings that were falling. You had beautiful facades, but they were falling into ruin. And a pilot program allowed us to get that done. We built an office building at 677, where 677 Prime is located. We had pilots there. And pilots, by their very nature, expire.
What's the average? 5 years?
5 years.
Yeah.
I think the one at 677 might have been 7 years. But what you have to prepare yourself for is that's going to raise the rent.
Yeah.
Because now you got to cover the property tax that you got relief from for the first 5 years, 7 years, 8 years, something like that. So I think pilot programs are very useful when given to the correct project. And I think it's less important who got the pilot, because I don't care who you are, nobody is going to build a project for free or worse at a loss.
What prevents companies from backing out after that 5-7 years, and now you've got vacant buildings?
Well, these buildings are always privately owned. So, and quite often with the more sophisticated clients, they're privately owned by the people who own the construction company. So they don't want, they're very smart people. They project at some point we're going to be able to break even and make money when the pilot goes away. So it's not like they're going to just give you the keys.
So they're hoping that the business is now on its feet, whatever one that they're investing in, and it can handle that raise in rent.
Yeah, and if you go down and look at I forget what they replaced the Wellington with, but the Wellington, particularly in the legislative session, you can't get in that hotel. So it generates what they like to call positive cash flow. And to my mind, the pilot actually did what it was supposed to do. I understand that in some circles it's not positive. And it's sort of in the eye of the beholder. We have a situation in Gilderland right now where there's a dry cleaner. and it's dry cleaner went out of business 30 years ago.
Oh, that's right across from my old office, right?
Right across from your own office. And the site is polluted and needs to be cleaned up. And there's 4 or 5 other dilapidated houses or former business on the location, and a real terrible intersection where Foundry Road comes into Western. And unfortunately, the cash flow doesn't work for an apartment building that meets a density requirement and a height requirement. So what's in front of the Gilliland Town Board right now is some sort of variance to allow a slightly larger building to be built. And it's not like twice the size. It might be 10% bigger. And a lot of people in the town don't like that. But they're, that leaves you with an eyesore and a polluted site, and it's adjacent to a creek. So sooner or later, you're going to have to deal with it. Fortunately, the town board has preliminarily allowed the development to progress, but there's a lot of this not in my backyard stuff that goes on, as opposed to taking the big picture, which is we're going to take this eyesore, we're going to reconfigure that intersection, and we're going to clean up this pollution before it gets to the waterway. All of those things should be a win. And if the cost is a 10% larger building, I don't know. It doesn't seem too dramatic to me.
No, and what a great location.
Yeah.
That is. I mean, there's been nothing there as long as I can remember. I think there was a Dollar Saver and
there might have been a sign store maybe.
Yes, and a towing place.
Yep.
Yeah, but they were kind of just plopped down and throughout this property. Now, isn't that near the watershed of the Normanskill, right?
Yeah, the water flows away from the Normanskill there. So they're not so much worried about getting into that, but it flows downstream, and all the properties downstream are affected by it. And eventually, you're going to get in the groundwater of houses that use wells, which is a problem. Because Foundry Road is one of the older parts of town, and there are parts of that roadway where people just have a well.
Have you ever had to do remediation stuff with BBL?
Not with BBL. I've had to do it with a manufacturer over in, they're called Troy, but they're not in Troy anymore. They're in Waterville. And that had to do with what was there before. Dry cleaners, fuel stations, notorious.
It's always a dry cleaner.
It's always a dry cleaner. There's a local establishment in town called Across the Street Pub. Well, Across the Street Pub, nobody really knows this, but it is the old Albany Country Club equipment warehouse.
That's right. You were telling me that the other day.
And so they have a groundwater problem from the fuel tanks because, metal fuel tanks rust if they're not maintained properly, even if they are, and then they leak. And you can find yourself purchasing a property like that, and even though you didn't do the pollution, you own the property now. And the state has a very innocent-sounding title for you. You're called a PRP, potentially responsible person. So you could get the bill for cleaning that site up, and it was polluted when you bought it.
It sounds like a New York State thing. That's it.
These things require money.
Yeah.
And, if particularly states that are strapped for cash would rather get the money out of you. And if the pollution, and you've owned the property long enough, you will have insurance that did not have a pollution exclusion clause on it. Pollution exclusion clauses in insurance companies came into favor right around 1980. And so that's today, you could have insurance from back in that day. The problem is trying to find who the insurance was with and where the policy is. And there are actually people called insurance archivists who actually go back in time and try to find the coverage. I've had those cases. That situation developed over asbestos. Asbestos litigation started with the people who manufactured it. Well, they all went bankrupt.
It was probably DuPont or something like that.
There's several. But now, I've had asbestos lawsuits in my office since I started, and I've been a lawyer now 42 years.
Wow.
So I have had asbestos lawsuits, and what they've done is they've moved on to the supply houses. Now, the supply house, it all depends when the exposure happened as to whether or not there's insurance. So what we find out is when we detail where the exposure was, sometimes we can shoehorn it into insurance coverage, and sometimes not. And so the only way out of that, if you have too many of those lawsuits, is to take your company into bankruptcy.
Ugh.
Yeah. But it's all revolving around the pollution exclusion clauses, which came into effect around 1980.
Okay.
So before then,
Is that federal or state?
that's national. Okay. In other words, the insurance policy clauses are governed by state law. Okay. And what happens is one insurance company gets it approved, whether it's in New Jersey or Florida or wherever, that they then, imitation is its sincerest form of flattery, right? Mm-hmm. So that's what they do. And so it can be very difficult if you're a company that maybe you inherited from your father or your uncle, or maybe you bought it or your dad bought it. And the last thing on your mind was the fact that you sold asbestos roof shingles was going to expose you to asbestos litigation, 40 years in. Mm-hmm. And that's what's happened. And it isn't just the person who is exposed to it, but of course he came home and took his blue jeans off and the wife put them in the washer. And so you will see people bringing lawsuits on behalf of family members. It still goes on today. And it can be a mess. It can be very, very expensive on the companies. And difficult choices have to be made sometimes. Mm-hmm. Because, of course, the company's a going concern. It has assets. And, if you're going to go bankrupt, those assets are going to end up being around for your creditors, one of which will be the people suing you for asbestos exposure. Even though you didn't manufacture it, you just bought it. It came on a truck in a box. You unloaded the truck and put the box in your warehouse. Then you took the box out of the warehouse, put it on a delivery truck. That, and that creates a asbestos litigation exposure.
Huh.
Yeah. So there's a bunch of those kinds of things that can rear their ugly heads and cause a lot of financial heartache.
You may not know the answer to this, but how are those cases handled in other states? Because I know New York is pretty big on insurance or general liability and workers' comp, and a lot of other states in our country are not. So if those come up, how's that handled?
Well, I'm going to give you a chance to show off.
Oh,
what
boy.
is the most litigious state in the union?
You got me. What is it?
Florida.
Really?
Yeah. Yep. By far, they have more lawsuits per capita in Florida, and all you got to do is turn your television on down there. Every commercial is about that.
That's because all the old drivers, they're just hitting every.
Anyways, but yeah, and it's really kind of strange because Florida is one of the few states in the country that will let you register your car with no insurance at all. So you may just got run over by somebody, and he unemployed, has a wreck of a car, and has no insurance. Mm-hmm. Which is why having underinsurance is the most critical insurance you could buy, because that's the insurance you buy to protect you. Mm-hmm. And since you're paying for the insurance, odds are you should do so. Oh yeah, Florida, very litigious. Lot of condo litigation down there. I've been involved in a bunch of condo cases down there, and what happens is everybody knows who the law firms are, and they show up to your condo board, and they say, I got this engineer, Scott. He's going to look at the building and we'll give you an idea of where you stand. And he comes in with a telephone book full of defects.
Yeah.
And then the board, which has a fiduciary relationship to everybody who owns a condo there, they hire that same law firm to bring a lawsuit against the contractor And when the money runs out, they settle for nickels or pennies.
That's crazy.
There's a lot of that kind of litigation that really just generates income for lawyers. Mm-hmm. Everybody, I'm sure, has gotten in one of those class action, claims. All you got to do is join the class. Well, you stand to make $20. The lawyers who do that litigation, and of course they don't ever get tried, end up with $20-30 million in legal fees because there's 14,000 Scots.
Yeah.
And the $20. So that's why I throw those in the trash.
I remember when we first met going over conversations about how we're going to set up our business, not only with contracts, but insurance as well.
Yep.
And for a couple of years, we sat down once a year with you and Kathy O'Keefe, who was our insurance agent and still is.
Yep.
She's the best. I've had her forever. And she said, look, most people try to cut their expenses and get cut rate insurance. That is not a good idea. That's not part of the game. Part of the game is making sure you're almost overinsured in this industry so that you're covered and you can be in business in the long run, right?
Right.
And I remember you saying that to me and saying, if you figure that part of the game out, you'll be fine.
Well, there's a particular insurance company, I think they're out of Utica, Erie maybe, that writes a specific policy for subcontractors that it excludes contractual indemnity. Every contract that a subcontractor signs with a reputable GC requires that. So when it comes time for somebody to get hurt, the general contractor looks to the sub to pick up his defense. Erie disclaims coverage. So that's why it's important to have a very savvy insurance advisor, because there are disreputable people out there who insurance companies are great at collecting premiums. Mm-hmm. Not so much fun paying claims. So you want to be with a strong company, a reputable company. The insurance companies, that are cut rate do go out of business. And depending on how that insurance company is formed, you may be able to get coverage through New York State or maybe not. There are certain insurance companies that are called RRGs. They're a risk retention group. They do not qualify for New York State's Insurance Liquidation Bureau. And if they are out of business, you have no insurance.
I think that's one of the big benefits about staying local is you can go and sit down with your agent and go over these things. If you're doing it over the phone with a large company, you really don't know what you're getting.
Yep. And
I'm not a lawyer. I can't read half that stuff. It's written in such a way that it's supposed to be confusing. You got to set yourself up with a good agent.
Yeah, because also the agent picks the insurance company. And so the insurance company, the agent is like the insurance company's customer in a way, because they're not only bringing your business, but they're bringing my business and Bill's business. And so if they have a big, album of insurance program, the insurance company is going to listen to them on a close call. Mm-hmm. And that's the kind of thing that you really got to be very careful about how you choose. I went through this with a client who had a wonderful insurance agent who finally shut his business down, and they were bought by a big, huge conglomerate. And instead of having an insurance agent to talk to on the phone, they got an 800 number.
Oh, jeez.
And, in Chicago.
The general. Call the general.
Call the general. And you can imagine, the insurance companies are not too crazy about, and New York State, as you and I have talked about, is a very unique state when it comes to construction litigation. I mean, people have heard about the scaffold law, but unless you've actually been in one of those lawsuits, you don't fully appreciate what it means.
What is the scaffold law?
The scaffold law essentially says if you are injured, in essence, because of a gravity-related threat, fall off a ladder is the easy one, but how about a hammer falling off a scaffold? That's a gravity threat. And if you are the general contractor or the owner of a commercial piece of property, you are absolutely liable.
It's only commercial?
Yeah. Yes. No, you can, as a residential builder, you can be involved. There is an exclusion for 1 and 2 family homeowners, as long as they don't direct or control the work. And what happens is in the commercial setting, the owner says to the general contractor, "This is yours, buddy." And if he's a good general contractor, he's going to accept that because that's his customer. But if the worker was negligent in part, in causing, at least in part, his own injuries, that doesn't come into play under the scaffold law. And New York is the only state in the union that has that, because we have a very good trial lawyers lobby. And it's an extremely lucrative avenue. But if you're a general contractor and your contracts are up to date, you can manage that risk. I can tell you from the late 90s to today, I paid money for instance, on a general contractor, a big general contractor lawsuit under the scaffold law once. And the only reason I had to pay was it was one of those stupid insurance policies that had that exclusion I talked about.
So are you saying it gets passed down?
Yeah. It's all about risk transfer. If you're the general contractor, it's all about risk transfer. And if you can't get appropriate limits from a subcontractor, then you should probably look for another subcontractor. And if you're doing stick built, whether it's commercial or residential, the pool is not a lot of financially secure companies. So you got to be careful what you're purchasing, because there will come a day when you need it. And we see it when you're building a bank or a gas station or an auto industry kind of thing. You'll get contractors who aren't really up to snuff financially. Now, you don't have to lose your mind about it. You can pick and choose, depending on the trade, what limits you're comfortable with. If the guy's putting up partitions, office partitions, well, odds are you're probably not going to find yourself needing $10 million in coverage.
Yeah.
But if he's a site contractor or an electrical contractor, those are people, and if you got some folks who are going to be working at an elevation, those people you need policies from. And it's the same the world over. We did a lot of work at St. Peter's, and they had a Manhattan lawyer, and they came up with ridiculous insurance limits because they were used to Manhattan projects. So we had to work our way around that. So it's a constant thing going on. My recommendation would be, before you send out the first check, make sure you have proof of insurance. Because the guy may tell you, "Oh, I'm covered by Travelers." Okay, I need a certificate of insurance, and ideally, that certificate of insurance should be what they call primary. So it's the lead policy, and non-contributing. Because what insurance companies like to do is like to go back to the general contractor and ask for their insurance company to contribute. So you don't want that particular policy. You want it to be primary, non-contributing, and you want your company and, of course, the owner to be listed as additional insureds on that certificate. Do not settle for something called a certificate holder. A certificate holder only entitles you to notice if the policy is canceled. It provides you no insurance whatsoever. It is not evidence that the subcontractor has insured you. So even though you may have a contract that says the subcontractor is going to name you as an additional insured, don't take their word for it. Just make it a part of the pay rec system. The successful companies do that. I got your pay rec. I need your certificate of insurance to get you paid. And you'll hear some wailing and gnashing of teeth, but that's the situation.
And technically, it's supposed to be on a per project basis, correct?
Or
do they let you do per year now?
Yeah, it depends on the size of the general contractor. For instance, BBL's program is an industry-wide program. We don't have separate insurance policies per project. They're all part of that. But of course, that's all part of the renewal process. How much money did you actually earn? And it's driven by revenue a lot of times. And there's a lot of these traps you can fall into. One that's out there right now is the Unfair Wage Act. Okay, it's wage theft. is essentially what happens. And what the law has done is it has turned the general contractor into an insurer. So in other words, if you're on a commercial site and the subcontractor, for instance, say it requires a prevailing wage and they don't pay the prevailing wage, they can go back to the general contractor and get the money from him. So it's an absolute liability.
Really?
Yeah, it's an absolute liability statute. In other words, let's say that you got an affidavit as part of your pay rec from this subcontractor that they did all the things they were supposed to do as far as payment and benefits go. But they really didn't. So you've done your due diligence. You now have an affidavit. It's not a defense under the Wage Theft Act. And so we haven't seen too much of it around here, but there have been some pretty splashy cases down in the city about it.
Huh.
Yeah. And that stuff goes on. I had a guy call me, 6 months ago. He was building sidewalks for the city of Poughkeepsie. And the Department of Labor showed up one day, wanted to see his contract. Well, he wasn't paying prevailing wage.
Oh.
And in his pay recs to the city of Poughkeepsie, he said he did. I said to him, well, sir, you don't need me, but here's the name of a criminal lawyer because that's a felony.
Straight shooter Jack. Here he is.
That's a felony. Or as my old man used to say, I'm into reconstruction, not resurrection.
Yeah.
You are in so much trouble, you don't even know which end is up. And it's unfair to the other people who bid the sidewalk job because they bid it prevailing wage.
Absolutely.
And so I don't have a lot of sympathy for that.
No.
If you don't want to pay prevailing wage, then don't get into projects that are prevailing wage projects. Mm-hmm. The unions are very strong in New York, but as a result, we have really a quality construction industry. If you go down to Florida, where unions have been basically driven out of existence, the workforce is terrible. I've watched them. We've had projects down there, and we will sometimes bring subcontractors that we're worried about. We'll bring them from New York.
Really?
Oh yeah, one in particular. I can remember doing that because we just couldn't. There's no apprentice program. There's no nothing. Roofers down in Florida are notorious. The Jack and Scott Roofing Company went out of business on Friday, and now it's the Bill and Frank Roofing Company, and they just changed the decals on the truck. Oh yeah. So I know
that does happen here too, by the way.
Yeah. Well, not that I'm aware of. But yeah. Those are the kind of things that you have to worry about. And the bigger the contractor you are, the bigger a target you are.
Mm-hmm. What kind of projects you guys do in Florida?
Right now we had done a lot of condominiums down there. Right now we are doing surgery centers and medical office buildings. We do those around the country.
Oh my God, that's crazy.
Yeah, Texas, Tennessee. We just started. It's either in Idaho or Iowa. It's one of those I's.
Now, BBL's not a bid contractor anymore, right?
No, we haven't been a bid contractor since the early 90s. Once in a while, if it's a special circumstance, they may find themselves in a bidding situation.
So they've just found a niche that works for them, and their reputation is what.
Yeah, and it's a customer relations driven, and that came from Don in the early days. Anybody can be a low bid contractor, but not only do you want the customer to respond favorably to the way they've been treated, you want them to recommend you. And the medical side of BBL's business is all relationship driven. The doctors go to conferences, and it's very common around the country for doctors to want to own the buildings that their practice is in. And so if Dr. X says, I use BBL and they did a great job, you're going to get a call. You're going to get a call. So, and that was the business model they went to, and it turned out to be a pretty successful one.
Now, this is public information, so I can ask you this, but do you know what their top line is, BBL's?
I do.
In a year?
I do, but I'm not going to tell you.
It was in the Albany Business Review. So,
well, you'll have to look it up.
Yeah, but it's insane how big they've grown.
Yes. And when I first started working with them, they were a hard bid, small contracting operation. And with Donnie and the president, who's now chairman, Kevin Gleason, was remarkable what they did. It still exists today. It's a bigger company today than it was 5 years ago.
So Donnie passed. Gleason's getting out of it, correct? Or he says he's getting out of it?
He's getting out of it. He's still. I just was in his office yesterday, so he'd like to get out of it, but I also think he also loves to work, and he's obviously very good at it.
That's something we've talked about too. I have asked you, what do you want to do? Are you going to retire? And you can share your answer. I don't have to.
My answer is really simple. I don't know what I would do if I retired. If I play golf more than twice a week, I'm bored. And I really enjoy being a trial lawyer. That's what I enjoy doing. I enjoy working with construction companies because a lot of the cases I try are actually medical malpractice defense cases. But it's really the same exercise. It's figuring out how things work. That's the key to whether you're talking about construction or whether you're talking about a malpractice lawsuit. How do things work? How do these things go together? And you get to meet really smart people, and they get to teach me, and some of which I managed to retain. Jury lawsuits are an interesting way to meet the populace. I have tremendous confidence in juries. A lot of people will say, well, I don't want to, if I'm a doctor being sued, I don't want a jury of plumbers deciding my case. I'd rather have a jury of doctors. No. You want the jury of plumbers. Because together they're going to be really cool what they can accomplish. And although most people don't want to sit on a jury, once they've done it, it's a very positive experience. That's about a 99% reaction rate. They're very, very happy that they did it. And so I can't imagine not doing that. So I travel a lot, but I certainly can't go down and sit on a beach in Florida. I'd lose my mind.
Well, we're actually almost out of time here. I do want to ask you one more thing. What is the future of your company? Where do you see you guys in 5, 10, 20 years?
It eventually will be taken over by the younger people in my office. My son, though he lives in Manhattan, covers the southern part of the state for us. He's been a lawyer 10 years now, I guess. And how I see this working is in the next few years, I'm going to transition away from being the person running the business, which is the one thing I'd like to get out of, and become of counsel and just try my lawsuits. And then the young people can deal with running the business.
Basically putting the tool belt back on.
Yes, absolutely.
Interesting. It's coming full circle.
We're coming full circle. I was a biology major at Holy Cross. I never dreamed I'd be running a company. And I'm not really sure I'm qualified to do that, but it's worked out okay.
Well, Jack, thanks for coming on. I'm definitely going to have you on again because I don't think we've covered half the topics that we wanted to hit on today. But that's all for today. Thanks for watching the Build Right podcast. If you like what you're hearing, please subscribe, Spotify, YouTube, Apple Podcasts, or any of your major providers. I'm your host, Scott Raffensperger, and with me today, Jack Phelan from Phelan, and Danick. Thanks again, Jack, for coming.
Thanks for the invite.
We'll see you guys next time.